Judgment in the appeal, PMS International Limited and Magmatic Limited.
In 1998, Mr. Robert Lowe won a prize for designing a ride-on suitcase for children. Mr. Lowe subsequently updated the design, and in October 2003, he registered it in the name of his company, Magmatic Limited, as a community registered design, the CRD, which consisted of 6 images. Magmatic has manufactured and sold ride-on suitcases for children under the trademark Trunki, and the shape of those suitcases is very similar indeed to the design of the CRD. PMS International Limited import and sell ride-on suitcases in various styles for children under the name Kiddee Case, which Magmatic contends infringe the CRD. At first instance, the judge, Mr. Justice Arnold, concluded that the Kiddee Case infringed the CRD, but the Court of Appeal allowed PMS's appeal. Magmatic have appealed to the Supreme Court, and today we unanimously dismiss Magmatic's appeal. Community registered design is governed by an EU regulation whose effect is that the Kiddee Case infringes if it, and I quote, does not produce a different overall impression from the CDR. In deciding that issue, what matters is the overall impression created by the Kiddee Case as against the CDR and the effect on potential customers. In considering an issue of this nature, an appellate court should not reverse a judge's decision unless the judge has erred in principle. The Court of Appeal decided the issue of infringement for itself and came to a different conclusion from the judge because the Court of Appeal considered that the judge had made 3 errors. The first criticism was that the judge failed to give proper weight to the overall impression of the CDR as an animal with horns, whereas the impression made by the Kiddee Case was either an insect with antennae or an animal with horns. The overall impression given by the CRD is indeed that of a horned animal, and the judge did not specifically refer to that when comparing the CRD with the Kiddee Case. A judge cannot be expected in every case to refer to all the points which influenced his decision, but when, as here, he has given a full judgment, identifying a significant number of points which weigh with him, it is fair to conclude that he has failed to take into account an important point if he has not mentioned it. The second criticism was that the judge failed to appreciate that the absence of ornamentation on the CRD reinforced the horned animal impression. This has some but limited force. Any decoration could detract from the animal impression, although it is a relatively minor point which simply mildly reinforces the first criticism. The third criticism was that the judge ignored the color contrast on the CRD images and described the CRD as constituting a claim, and I quote, evidently for the shape of the suitcase, so that decorations on the Kiddee Case were to be ignored when making the comparison. However, although the CRD images had a body which was uniformly grey, it also had black strips, a black strap, and black wheels. The natural inference is that these components were intended to be in a contrasting colour to the main body. Accordingly, the judge was wrong to hold that the CRD was simply a claim for shape. The Court of Appeal were entitled to consider the question of infringement for themselves, and as they approached that question on the correct legal basis and reached a reasonable conclusion, we should not interfere with that decision. This court has sympathy for Magmatic and Mr. Lowe, as the Trunki was a clever idea, which PMS copied. But design right is intended to protect designs, not ideas. Magmatic also contended that the second criticism raised the question whether the absence of ornamentation can be a feature of design, and if so, whether it was a feature of the CRD in this case, and further, that these questions should be referred to the Court of Justice of the European Union, as they are neither acte clair nor acte éclairé. We reject this contention, The Court of Appeal did not, in fact, decide that absence of ornamentation was a feature of the CRD. In any event, it is clear that absence of ornamentation can be a feature of a community-registered design. Accordingly, no reference to the CJEU needs to be made, and this appeal is dismissed.
Judgment